The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Thank you. Please be seated. Call the third case on this morning's docket. That is case number 105854, State of Kansas v. Stanton, Holt.
Thank you. May it please the court, Sam Kepfield of Hutchinson appearing for the appellant Stanton Holt. I would request 3 minutes of rebuttal time, and I'm ready to proceed.
3 minutes is granted.
Thank you, Judge. This is the sixth post-conviction petition that Mr. Holt has filed in Geary County District Court, and the sixth one that this court has heard. I don't think I need to go over the facts, so the court is well acquainted with those. I would point out a few things, though. I think there are several statutes and rules that are at issue here. The first one is, of course, KSA 223501, motion for new trial. The state has argued that this motion is clearly beyond the 10-day limit found in 223501, and that because 223501 is mandatory, that this petition must be dismissed as being time-barred. I disagree. I think, as I outlined in my brief, the language in 3501 makes it a directory rather than a mandatory, and I think, as I will explain later, I think Mr. Holt is entitled to file this motion even though it may be 20 years almost after his trial and conviction. He's also asking in the petition, asking for DNA testing. That is his right under 212512. The standard of review here, I said out in my brief, I was wrong. The standard of review here under Bellamy is de novo. It means this court grants no deference to the rulings of the trial court because you have the record, all 2 boxes of it, and you've reviewed it for yourself, and you can review it for yourself again after arguments, but you can draw your own conclusions. You do not have to rely upon the trial court's conclusions as being binding. So the question is, what does Mr. Holt want? Well, first of all, obviously he wants out of prison. But secondly, more importantly, Mr. Holt wants an evidentiary hearing on the merits of his motion, and this has not been done before. There are 4 points that we have to take into account here. The first one is that these petitions, the state petitions and the ones that have been filed in federal court, have all been pro se. Mr. Holt is incarcerated, I think, at the Lansing Correctional Facility now, but he's been in DOC for 20 years. He has not had the assistance of counsel in drafting any of these petitions, and I think that's manifestly clear to anybody who reviews them. I'm not sure of his educational level. He was in the Army. I think he was in the Army prior to, or at the time these murders were committed, so that would, I think, imply he has some, possibly a GED or high school diploma, but his educational achievement is probably limited, as is his intellectual abilities. He does not have the knowledge that you or I would and the ability to draft a petition like this, so you have to construe these liberally. The other thing I think you need to remember is he more than likely does not have access to that 2-box record that you have. He has probably asked the clerks for transcripts of the trial, sentencing, and the answer he's more than likely gotten is, well, sorry, you got to pay for it. We're not going to copy it for free. I think he's filed motions for transcripts which have probably been denied. So he's not working from a complete record, so if his petitions are, as the state says, lacking specificity, that's probably why. So you have to construe these liberally and take that into account. The second thing, and I think this is probably the more important thing you have to remember, is I think there has been ineffective assistance of counsel provided to Mr. Holt during the pendency, the whole time of these post-conviction hearings. His first petition, as the court has noted, was filed in 1997. He was initially granted an evidentiary hearing, but his counsel said, I can't find anything here. There's no reason to have a hearing. I agree with the state. We should dismiss it. And it was dismissed. exactly that sort of advocacy or lack of advocacy was at issue in Campbell versus State, if you recall. That's a 2005 case where essentially the court said that
Campbell wasn't on a motion for new trial.
1507.
6 or so post-conviction relief motions later.
But what I'm talking, well, I agree, but everything we're here today, everything flowing from that first hearing that Mr. Holt had. I mean, his counsel at the first hearing said, "There's nothing here, Judge, dismiss it." And that has prejudiced, if you look at the record, clearly that has prejudiced every subsequent petition that he's filed. And I think
what was the avenue to raise that? Was there, I mean, in other words, if we accept that he had ineffective assistance or inadequate assistance on his first 1507 under the Campbell case or other cases similar, what was the appropriate time and motion or petition to raise that issue? Should it have been done on appeal from that decision? Should it have been done by the filing of a 1507 saying counsel was?
Yeah.
I mean, help me out on that, because we are a long time gone on that decision.
Well, I agree, we are.
And it wasn't raised in any kind of, it wasn't raised until this action, was it?
No. Well,
and so even if it's a 1507, it would support a 1507. He's way out of time on a 1507.
Unless the court says he's not. Well, the first appeal, number 81489, that was Court of Appeals issued that in January 1999.
Mm-hmm. And it wasn't raised in that appeal.
No, it wasn't. Well, it wasn't right. Not that I didn't do this. I've handled one of the prior appeals in this matter. I have not been trial counsel on any of his. But
as we know today, as far as we know today, it wasn't raised at any point in that appeal from that first action.
Not that I can tell. Again, it's been a while since I've looked at the record. I will. If it's not in there, I will agree. It may not have been, but the first decision is like a page long. It's not raised.
And I have a note here that there have been 4 1507s.
Yeah, I think that's correct. 4 1507s and motions for new trial.
It looks like.
Probably
a motion to correct a legal sentence,
right.
A motion for a new trial, 4 1507s, and a 2254 petition in federal court. Yeah,
I think there have been several federal petitions, and I'm not sure if those may have been appeals from denials here in state court. I have not handled those, but I'm going to go on a limb here and say those federal petitions have probably been the same. They've been drafted pro se and summarily dismissed by the federal courts as well. But you're right. Yeah, the ineffectiveness has not been raised until now. I alluded to it in my brief.
And you're saying that about the handling of that first 1507 only? Because it looks like, I don't know the specifics, but just in looking at the summaries, it looks like ineffective assistance of counsel has been raised in at least 5 of those motions.
Well, ineffective assistance of trial counsel.
Those are all trial counsel?
Yeah. What I'm saying here is, and pardon me if I'm confusing you, I'm saying here is that his first post-conviction counsel was ineffective. Now, again, it's a statutory right, not a constitutional right, but the courts have said, this court has said in the Brown case that it applies to appeals, and then in Campbell, the Court of Appeals extended that to trial level counsel. That you have to have appointment of counsel, and it cannot be, as I think you said in Brown, a useless formality. I mean, we've all gotten cases like this. We've all been appointed or retained to handle post-conviction cases that you look at them and you think, well, there's not much here. But you do your best. I've had cases like that. I've got a couple now. You do the best that you can. You try and find something. You don't simply say, you're right, Your Honor, there's nothing here. I agree with the state. Dismiss it. That's ineffectiveness. And that has prejudiced Mr. Holt.
Counsel?
Yes.
A moment ago when I said he's way out of time to be talking about this, or I suggested that he might be, you said unless the court says he's not. Kind of sotto voice. Well.
There are exceptions to that.
There's an exception, manifest injustice under 1507F. And then you need to show us something about
Manifest
why
injustice.
it's manifestly unjust.
Yeah.
Unjust. So could you do that?
Sure. Yeah. The manifest injustice is that his counsel. If you read the Campbell decision, the counsel essentially said there's nothing here. That's prejudicial.
That's about whether there's error or whether there was a failure of counsel, not about whether there's prejudice flowing from it. Don't you have to show us something about the merit of his claim to show us that the result is somehow different or there's really an unjust result?
I can't do that because we don't have a litigation on the merit. I can't do that. Okay. At least not now. I mean, we've never been able to do that because there's never been a litigation in ruling on the merits, yes.
But how can it be manifest injustice if counsel was spot on correct, that there wasn't anything there?
I don't know if there's nothing there. I don't know. If there, I guess if you review the record and you take it on faith that there's nothing there, then this is a fairly easy decision for you to make. Like, no, there's nothing there, no prejudice. But I would note that there was at one point he did get the last time. I think he got a small victory, as they said, they convicted him on a misdemeanor count that had been dismissed prior to trial. They sort of overlooked that. So, the record is not perfect.
Can I go back a little more
Yes.
fundamental? You said unless we decide differently, we decide manifest injustice. Is that our call, or the way the statute's written, isn't that, at least in the first instance, a district court call?
That's what I meant. Yeah, the trial court has to make that call. I mean, he will have to show that prove to the district court that there's manifest injustice, and I would argue that simply not being granted a full hearing because of his first post-conviction counsel's admission or statement of the court that there's nothing there, which appellate courts in the state have held is ineffective advocacy, that is manifest injustice.
I think,
Yes.
I'm sorry, go ahead.
No, please, go ahead.
My interpretation of Judge Segarra's order is that she also found this was a successive motion.
No, it's not. If you look at Rule 183, to be successive, there has to be a prior determination on the merits. We haven't had that. Every one of these has been summarily dismissed. They get the motion. These are badly drafted. I worked at the Legal Services Office at Hutchinson Correctional Facility for 5 years. I've seen stuff that would make this look like War and Peace, but it's not well drafted. The courts get these, and I think there's a tendency to say, gee whiz, he's filed another one. You look at it, you issue a perfunctory decision saying, you recite the facts, denied, no hearing. They're not successive. There's been no litigation. They were supposed to do it the first time, have an evidentiary hearing, but his counsel said, no, don't need one, there's nothing there. So they're not successive.
And to get to all of this, whether it is successive, whether there is manifest injustice, you have to ask us to convert this into a 1507. Is that right? Because that's not what he filed.
Well, no, he filed a motion for new trial. He's asking basically that he should have a new trial on this, citing all the reasons that he set forth.
And when it is determined under the statute that he filed his motion under, that he's more than 14 days too late, then what is our standard for determining whether we move past that procedural hurdle?
I suppose I don't know the answer to that. He probably, you could view this, I think you could view this functionally as a 1507. If you go back, I'll agree with Mr. Opat. This is probably the same thing he's filed 5 times before. I'll give you that, okay? He probably thought, well, gee whiz, I filed 1507s 4 times, didn't get anything. Maybe I'll call it a motion for new trial. Maybe that'll do it. I don't know what his thinking is, but I'm pretty sure that may have crossed his mind.
How do we get around the fact that the plain language of the statute that he filed under appears to procedurally block us from proceeding on the merits?
Well, as I pointed, well, you are not going to proceed on the merits. The district court will proceed on the merits. You look at the language. It is not mandatory. It is directory. There are a number of instances I point out in my brief where you can say, it's directory. It's a good idea if he does it within 10 days, but it is not an absolute bar.
Wasn't that position pretty much rejected by this court in Bradley in 1990?
Well, I'm not familiar with the Bradley decision, but I'm arguing here that the facts in this case are probably different than we have in Bradley, and that you have a series of denials flowing from an initial, I would say, botched post-conviction motion. And he is simply trying to. And the other thing is the standard review here is different. Those prior cases had an abuse of discretion standard. Now, since the Bellamy decision, it's de novo. You can look at the trial court, the record in the trial court, and you can disagree with them because you've got the record. You can draw your own conclusions. As far as,
but Counselor, I think where the Chief Justice is getting is it doesn't really matter how meritorious his claim might be.
Yeah.
As you're arguing, if the time limit is jurisdictional, and I think we've had some cases that at least intimated, if not specifically said, that it's filing the motion for new trial within the time set forth in the statute is jurisdictional, then we can't really give relief, no matter how meritorious the claim, if we can't let your client get into court, right?
There's no explicit provision in the new trial statute for manifest injustice. There is in the motion to withdraw a plea, and there is in the 1507 statute. I mean, I don't know if you want to engage in judicial activism and read that into this statute. I suspect not. And if you don't, then as I said, if you decide there's no exception, then this is a fairly easy case. You will affirm the district court, and we'll be back here in 2 or 3 years. He'll have read the decision. He'll file something else, and we'll be back here. I can guarantee it. If you decide it's jurisdictional, then that's it. But I'm saying that my reading of the statute is that it says 14 days or in any other period to be created by the court. And there wasn't an application to file it out of time. That might have been a good idea. The court probably would have denied that. But again, I think you have to realize who we're dealing with here. It would be inexcusable neglect if I did that, if I filed a motion for new trial, 18 years after my conviction. But we're dealing with a prisoner in the Kansas Department of Corrections with limited resources, probably limited educational achievement, who is doing probably the best he can. And again, if the only avenue I have is that the court can enlarge the time if it so chooses, that wasn't done. I don't know if you can read anything into that or not. But what we're asking is that you reverse the district court. Mr. Holt would ask for you to reverse the district court and remand it to the district court with directions to hold an evidentiary hearing, to appoint him counsel who can meet with Mr. Holt, sit down with him, bring the record, and say, okay, let's go through this and decide what your objections really are. Let's put it in language that can be clearly understood by district court. Let's put it in terms that are understood and understandable, and let's have a hearing. Evidentiary hearing, full evidentiary hearing on the merits. You can call witnesses. You can produce evidence. That's what we want. If there are no other questions, I thank you for your time.
Do you have any further questions of counsel? Thank you, counsel.
May it please the court, Stephen Opak, Geary County Attorney for the state of Kansas. As Mr. as counsel has, Mr. Ketfield has suggested, this is Holt number 7. I'll put a disclaimer like he did. I wasn't involved in the original case. I have been involved in some of the post-conviction matters, and particularly this one, which Judge Segura dismissed because she felt that the time limitations of the new trial statute prohibited her from ruling otherwise. She also commented that in order to obtain relief under the extension of the time in the new trial, you've got to show some exceptional circumstances. You've got to allege something that, if it were proven, might make a difference with the result that occurred 19 or 20 years ago. If you will look at Mr. Holt's pleading, and I know you have, it's captioned, motion granting new trial, forensic DNA testing underneath. But if you will read it and you will compare it to every other pleading he has filed, it's almost verbatim identical. And so in that regard, I suppose you could look at it as a 1507, because what he's asked for, what he's alleged in asking for the relief under which he has captioned his pleading, is identical to that which he has alleged at least 5 other times. Much is made about the fact that these are not successive. They are successive. The definition of successive is if the court finds that the pleading constitutes an abusive remedy, the court can consider that to be successive, whether there was an evidentiary hearing or not.
There's no requirement that the merits have been heard ever.
Right. That's the Brooks case, I think, State versus Brooks. The pleadings in every one of these post-conviction matters has been almost identical. There has never been, as Mr. Ketfield suggested, an evidentiary hearing, probably because the court, upon reviewing them, and the appellate court, upon reviewing the action of a district court, has found them to be successive and has found that no relief can be granted. If you'll look at the very first pleading that Mr. Holt filed, which was 199 pages, this was after his direct appeal, you will find on page, and I think it's page 6 of his pleading, I think it's in the record, I know it's in the 2 boxes full of files that I read, most of which were from the trial in this case. Almost everything he alleges in paragraph 10 state concisely all the grounds upon which you base your allegation that you are being held in custody unlawfully. Almost every one of those, if you boil it down, is the product of a ruling that the court decided when it affirmed his conviction in the direct appeal. And as to whether or not counsel who represented him at the first hearing should or should have not acquiesced, I can't answer that. Having been a defense lawyer for a considerable period of time, I found myself confronted with that obstacle also. How do you engage in candor with the tribunal before which you appear and argue something that you don't believe in? Argue something that you believe to be frivolous? I don't know the answer to that. That's a tough question, and it's one of those things that pops up from time to time. I know you're supposed to advocate zealously for your client. How do you do that when you don't believe, or when you believe it's frivolous, frankly, and it's repetitive? Each one of these petitions has, in fact, been repetitive. If you will look at what he has alleged and what Judge Segura considered in this particular petition, which is the 6th petition after his direct appeal, although it has a different caption, he alleges defective complaint information. That issue was decided, and I'm going to cite the appellate numbers. That issue was previously reviewed and decided adversely to him in 81-489, 89-273, 96-169, and 96-270. He talks about DNA inconsistencies. And when he talks about that, he's not asking for any retesting under 21-25-12. He's simply stating again his argument that the DNA evidence that was introduced at his trial was somehow inconsistent. And he doesn't really say inconsistent with what, but he calls it repetitively throughout his pleadings DNA inconsistencies. That issue was examined in case 1001-563 and decided adversely to him. He is not asking in this latest petition for retesting, or he is not, in fact, he's not even alleging the facts or making the allegations that get him to first base under 21-25-12. He's not suggesting there's evidence that is not tested, or that if there were evidence that it could be retested with newer and more modern technology. He makes no mention of that in this pleading at all. It's totally absent. He alleges, again, prosecutorial misconduct. He's alleged prosecutorial misconduct in every pleading, and in fact, I believe that issue was also addressed in his direct appeal. Each time decided adversely to him. Finally, in his latest petition, he alleges biased selected juror / jury foreman. That issue was addressed in 89-273, 96-169, and 1001-563. All of these issues have been decided adversely to him. That's why they have been held to be an abuse of remedy. They have been held to be a successive petition. They have held to be not. I think Judge Hornbaker, the time before last, or at least the case that this court ruled on in December of 2011, I think Judge Hornbaker called the pleadings frivolous, and of course he made an order barring Mr. Holt from filing any more petitions. You reversed him on that, appropriately so, although I argued to the contrary. But Mr. Kepfield's right. I suspect you're going to see a Holt 8, and maybe a Holt 9, and maybe a Holt 10. The problem is that unless he addresses these things in the proper configuration, he's never going to get any relief. In order to get a new trial, he's going to have to allege something than what he's alleged here, because the time's long past for that, and Judge Segura rightfully found that to be the case. If he wants DNA testing because of some evidence that, frankly, is unknown to me, and I've reviewed the file, then he's got to do it in a different format and make allegations that can be supported. He's not done that in this. Judge Segura dismissed this petition, and frankly, I think she found it was successive. She considered it to be an abuse of discretion. I think that's the standard of review for both the granting of the new trial and for considering any allegation made under 60-1507. We've heard a lot of argument about the defendant's claim of ineffective assistance of counsel. This court addressed that, I believe, when it ruled in December of 2011, when the court said, for the only claim we review on Holt's appeal, in this particular case, which was 1001-563, the lack of hearing on his claim of ineffective assistance of counsel, he argues for the first time that his three prior 1507 motions were improperly dismissed without an evidentiary hearing. His right to argue the lack of prior evidentiary hearings, however, ended with his direct appeals on those particular motions. See State v. Richmond, issue not briefed is deemed waived or abandoned. In reviewing Holt's claim of entitlement to a hearing for his fourth motion alleging ineffective assistance of counsel, we are unable to ascertain any specific instances of conduct to determine whether his trial counsel's representation fell below an objective standard of reasonableness. Holt makes only conclusory contentions without an evidentiary basis to support his claims. That's basically what's happened in each one of these petitions that he has filed, which the district court has dismissed on 6 prior occasions, and which the appellate courts, including federal courts, have reviewed and dismissed without granting him any relief. I believe that under the format within which this matter was presented to Judge Segura, in which it's being presented to you, Judge Segura's determinations ought to be affirmed. I don't know what else I can say about it. I suspect that we're going to see another petition, and as Mr. Ketfield suggested, I hope I'm not here in another year or two arguing the same thing. I hope at some point in time, like Mr. Holt, I might retire.
Do we have any questions of counsel before he retires? Thank you, counsel.
Thank you very much.
I want to respond to a couple of points. First of all, I did check the Bradley case, and that the holding, at least in the little annotation, says that there is a method to request new trial. 1507 can be used to request a new trial for newly discovered evidence after the statutory limits in 223501 run. So this is not being made on newly discovered evidence. I think, as Mr. Hope has extensively pointed out, all this stuff is rather old. It's been here before, but I keep emphasizing the issues. Mr. Opad is incorrect, though. These issues, the substantive issues, have not been determined adversely to him. What we're dealing with in every one of these appeals is whether the trial court erred in summarily dismissing the petitions. There's a difference. They don't get to the issues. They don't get to his claims of ineffectiveness of trial counsel, the DNA evidence, the prosecutorial misconduct. Those aren't addressed in any meaningful, substantive manner. It's simply that the trial court have reason to summarily dismiss these without an evidentiary hearing. So, and again, I'm saying that there is, look at Rule 183D2. That defines successive motions, at least for habeas corpus petitions. And it says there has to be a prior determination on the merits. You don't have that here. This is procedural stuff. It's not substantive. As far as, the exception, how do we get around that 10 or 14? Yes.
If you have a summary dismissal, that the test for that is whether the motion files and records conclusively show that Mouvant is not entitled to relief. Isn't that a determination on the merits?
That's the trial court's opinion. I don't believe it's simply, well, there's no record of it. I mean, the trial court simply declares there's nothing here. It's not adversarial. I think a determination on the merits, I think for 1507 and for this implies some kind of adversarial proceeding. You can't just have the court look at the file, review it, there's nothing here. You have to have an evidentiary hearing.
It's akin to a summary judgment. Isn't a summary judgment a judgment on the merits?
It is, but again, I'm saying
a granting of a motion to dismiss is not on the merits of, at least of the pleading.
Well, and I would that's true if you're talking about civil cases, and I'm not as familiar with civil law as I should be.
But this
is
a civil action. This is a civil action.
No, I do mainly criminal, but I'm thinking that at least with criminal, you have presentation of evidence. But you don't have that here. What you have essentially is the court reviewing the petition, reviewing the evidence without any sort of argument. I think there has to be some presentation by counsel, some adversarial proceeding. The petitioner would put on evidence, state would move to dismiss, granted, okay. But you don't have that here. You don't have any kind of, Mr. Holt has never really had a chance to get in front of the court. He's appeared pro se, but, he really needs an attorney to sit down with him, narrow the issues, define the evidence, figure out what witnesses and exhibits he needs. That has not been done. And again, as far as getting around that 10 or 14, I think it was a 10-day limit, this court, I think, has ruled that pro se motions to withdraw pleas under 223210 can be construed as petitions for writs of habeas corpus. I think it's pretty clear that that's what Mr. Holt is trying to do in this case, that he is trying to file a habeas corpus petition, hasn't had any luck the first 4 times he's done it, So he's really taking a 1507 petition, putting a different, and granted possibly a misleading caption, inaccurate caption on it, and trying to get his convictions reversed and vacated.
Counsel, before you sit down,
Yes,
I wanted to ask a question, several questions. First of all, my notes indicate that in your opening remarks, you indicated that this particular claim is the first time it's been raised by your client, and that claim is ineffective assistance of counsel in his first post-conviction relief attorney. Did you say that?
I said it. I alluded to it in the brief. I don't. Yes,
And is that your position today?
It is, but I will say this with this caveat that it has been some time. I did check the record out, both boxes. I reviewed the record. From my recollection, I think this is the first time that he has said, or his counsel has said, that first post-conviction hearing was flawed, and everything flows from that. It sort of tainted the whole process.
And you were present a few minutes ago when opposing counsel recited to us a quote from Holt, a decision this court released a year or two ago. And I wasn't writing down what he said verbatim, but he appeared to be addressing your comment by saying, we addressed those issues in that decision, in which we were specifically saying that Mr. Holt had raised ineffective assistance of his prior 1507 counsel, and we disposed of those claims. So are you in a position right now to tell us anything more about what we did in that decision and whether it colors your position that you took a few minutes ago?
Well, if that is in fact accurate, then I was mistaken. If Mr. Ropat's correct and that was addressed in the last, I think, decision, then I am in error, and I apologize. I'm not deliberately trying to mislead the court.
And then we would be faced with a successive motion. Is that right?
Well, again, no. Successive, my position is that a successive motion requires some kind of determination on the merits after an adversarial proceeding.
We've never said that, though, have we?
Well,
In fact, we've done the opposite lots of times, haven't we?
you have, but I think in this case, I'm disagreeing with you.
Yeah, I was concerned when I listened to what you were asking us for at the end of your previous portion of your argument, because it strikes me that it would just be true of everyone who ever filed a 1507. That if what we have to do in order to ensure that it's being handled appropriately is appoint them counsel, let counsel go out there, visit with them about their case, decide if they have something to put in a sensible motion, then let them have an evidentiary hearing. Doesn't that just wipe out all of the ability to do summary dismissals of non-meritorious claims?
Well, I think it's the better practice if you're appointed to.
It'd be great if everybody could have a lawyer.
That's what I try to do. I try to contact my counsel, say, "What are you trying to do? What are you getting at here?"
It's not very feasible, though, is it?
I guess that depends on your calendar.
Well, I'm just asking
if you're counsel, I guess if you're a court, it may be asking a lot, but I think this is an illustration of the adage that hard cases make bad law. I think this is an unusual fact pattern. He's filed 6. This is his 6th post-conviction petition of one form or another. I don't think that I've dealt with another client who's filed quite so many, probably because they haven't been in prison as long as Mr. Holt has. But, I mean, essentially, it's the facts in this case, I think, set it apart. That everything, that first hearing was somehow flawed, and if you've decided that there wasn't any problem with it before, okay, then I don't have much of an argument. But again, my view is that he's never really been given a meaningful opportunity to present any of the claims, and there's never been any real meaningful discussion on the record as to whether those claims might be meritorious or not. I'll grant you some of them may not be. Some of them, I may, counsel would sit down and say, this is for direct appeal. We got to knock this up. Prosecutorial misconduct is normally reserved for direct appeal, unless you can find some constitutional dimension to it. So I guess, you've construed motions to withdraw a plea as being functional 1507s. I guess probably one of the only avenues to get around the time limits here would be to do the same thing for this, is to say this is what he's trying to do. He's captioned it differently, but he's effectively trying to file a habeas corpus petition.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.